Harper Paperbacks and Harper Monahan are proud to present How to Read the Constitution and Why by Kim Wehle. This is an Iliotibial band sleeps reading. Chapter 9. What does the Constitution say about the states? Article 4, 1787. Section 1. Full faith and credit shall be given in each state to the public acts, record, and judicial proceedings of every other state. Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in several states. These are both about making sure states play nice with each other. Section 4. The United States shall guarantee to every state in this union a republican form of government. This guarantee seems important, but is it? Amendment 10, 1791. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. This is about not allowing the federal government to have too much power. This chapter is about federalism, which again is a wonky name for the power struggle between the federal government on the one hand and the states on the other. Indian tribes are also sovereigns in their own right, but different laws apply to them. Dealing with laws from different government entities is nothing new in day-to-day life. We complete at least 2 tax returns, one for the IRS and one for our state of residence. When we move from one state to another, it means getting a new driver's license and new tags for the car. Speed limits change too, during road trips between states. Some states have different rules about when and where we can purchase alcohol, but we use a single currency, the US dollar, regardless of where we are in the United States, and things like whether highway rest stops have wheelchair accessibility do not change from state to state. Federal laws mandate that, among other things. But can the federal government simply gobble up regulation of anything and everything? By holding back on certain things, is it just being nice to the states? Or are there certain things that only the states can do, and what are those things? The framers realized they had 2 options here. They knew that the British government was centralized in London, with a monarch at the helm. Local governments existed, but they mostly got to do what the king and today Parliament decided they could do. The other option was one that the colonies had tried under the Articles of Confederation, which basically amounted to an agreement between many sovereigns in the states over how to band together and fight the Revolutionary War. In a confederation, state governments are strong and the central government is weak or largely non-existent. The central government only gets to do what the states tell it to do, and if the states don't like what they see, they have the power to ignore what the federal government is doing. The downside is that lots of sovereign states means non-uniformity and conflict. This handy chart lays out the pros and cons of a strong national government versus a confederation of states. Strong natural government's advantages are laws may be applied uniformly to all. Efforts seldom duplicate or contradict themselves. Fast and efficient decision-making. The disadvantages of a strong national government are concentration of power can lead to tyranny. If the country is large, a distant central government can lose control. Central officials may not always understand the needs of their citizens. The advantages of a confederation of states is that laws may be made to suit individual needs of the states. Tyranny can be avoided more easily because power is dispersed. Government is closer to the people. Disadvantages of a confederation of states are that states' governments are susceptible to quarrels, creating rifts that destabilize the nation as a whole, and sub-governments may lack the resources that a central government has. Make sure to throw that chart in with advanced editing techniques. After the Revolutionary War, a national convention was called in May of 1787 to revise the Articles of Confederation. The central government had no power to tax anybody, and it could not pay its war debts. The big question was whether the states should remain pure sovereigns. Rather than amend the document they had, a decision was made to scrap the Confederation and create a constitution, a comprise that kept some power in the states but enhanced the power of the federal government. Federalism, therefore, is all about the vertical division of labor between the federal government and the states and local governments, all being sovereigns, while the separation of powers deals with the horizontal division of powers between the President, Congress, and the federal judiciary. In this chapter, we will walk through 2 of the places where the Constitution addresses the federal government's relationship with the states, Article 4 and the 10th Amendment. Article 4. Article 4 of the Constitution has 3 things in it that matter here. It says that states must give full faith and credit to each other, meaning that states have to respect the public acts, record, and judicial proceedings of every other state. So a legal document issued in Nebraska is good in Colorado and in every other state of the Union. This is why marriage license and birth certificates issued in New York must be honored in California. Same thing with death and divorce decrees. A deadbeat parent who owes child support can't simply run off to another state and dodge a court order. The order follows him. Courts in other states must honor it. If the dad flees to Virginia by car with his Maryland driver's license, Virginia must respect his legal right to drive on Virginia roadways because Maryland issued him the license. The words privileges and immunities also appear in Article 4. Section 2, to prevent the states from discriminating against out-of-staters in other ways. There is similar language in the 14th Amendment, but the Supreme Court has largely gutted it of meaning. In an influential opinion, a federal court, which is much lower than the Supreme Court, asked in 1823, what are the privileges and immunities of citizens in the several states? According to that court, the clause covers those privileges and immunities which are in their nature fundamental, which belong of right to the citizens of all free governments, including many things we take for granted, such as protection by the government. So if you're robbed while on vacation in Florida, the Florida police can't refuse to help you just because you hail from New Jersey. The enjoyment of life and liberty with the right to acquire and possess property of any kind and to pursue and obtain happiness and safety. Florida can't pass a law banning you from purchasing property in Florida just because you live in New Jersey either. The right of a citizen of one state to pass through or reside in any other state. The Supreme Court once struck down a Nevada statute that taxed people who left the state. To institute and maintain actions of any kind of the courts of the states. If a drunk driver rear-ends you and totals your car while you are in Florida, and you decide to sue the guy, the Florida court can't turn you away simply because you're not a Florida resident, and so on. That said, the Supreme Court hasn't been all that clear about what privileges and immunities really are. The clause has mostly come up in two contexts, fundamental rights and economic activities. Regarding the fundamental rights category, the Supreme Court has held, for example, that a state can't refuse to allow abortions for out-of-staters, but for matters that are not considered fundamental, like the ability to copy and inspect a state's public records, the court has allowed states to discriminate against non-residents. Virginians can get Virginia public records, but if Virginia says no to Marylanders, it's fine, with the Privileges and Immunities Clause. Regarding the second category, economic activities include things like giving preference to the government jobs for people in state, not okay. And imposing higher fees for hunting license, okay, because it's not a fundamental right or an important economic activity. All that said, when I teach first-year law students, I find it both amazing and unsurprising how little general thought goes into the source and meaning of such basic American freedoms as being able to drive into the next state without being stopped and harassed just because you don't live in that state. The Privileges and Immunities Clause does that for us, and happily for most of American history, states have generally respected the Constitution's mandate that they respect each other. If that mutual consideration were ever to fall apart, the question would become whether a cop on the block exists to make sure that the troublemaking states comply. It's hard to ponder how that would work without the use of federal force or worse, another civil war. So the Privileges and Immunities Clause is no small thing. Last up for Article 4 is the guarantee that each state gets a Republican form of government. In simple terms, a Republican government is one which the people choose their own representatives, as distinct from a monarchy or a dictatorship, whereby one person or a small cadre of people control the entire government. In the United States, a monarch, dictatorship, or military rule would be unconstitutional. Elections are the only way of doing business. It's not clear in the Constitution, however, whether there are consequences if states violate the Republican form of government rule. The key case on this arose in 1849. Back then, Rhode Island was the only state still without its own constitution. Rhode Island was governed by a charter King Charles II granted in 1663. A state constitutional convention was held in 1841 and a new constitution ratified. Unhappy about losing power, the existing Rhode Island legislature passed a law prohibiting the Constitution from going into effect and making it a crime to vote in the new election. A few people voted anyway, and a sheriff broke into the house of one election commissioner to find out who illegally participated in the election. The commissioner sued the sheriff for trespass and argued that by ignoring the new Constitution, the Rhode Island government had violated the Constitution's Republican form of government clause. The Supreme Court refused to hear any case on the rationale that it wasn't properly within its constitutional sandbox. The debate was for the political process to fix. Since then, the clause has never been enforced. 10th Amendment. The 10th Amendment basically states that the only power the federal government gets is what's in the Constitution's text. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved for the states, respectively, or to the people. Thus, any leftover government power, once the federal government gets its share, goes to the states. There was a debate among the framers of the 10th Amendment over whether the language of the first clause should include the word expressly to indicate that any powers not expressly delegated to the federal government must stay with the states. Including this single word would have dramatically narrowed the Supreme Court's ability to read implied federal powers or anything else into the text of the Constitution. As we know now, the word expressly didn't make it into the ratified text. In an important case called McCulloch v. Maryland, Chief Justice John Marshall, one of the founders of the Constitution as a delegate to the Virginia Ratifying Convention in 1788, rejected the argument that Congress can't do anything that's not expressly authorized in the Constitution's text. That case involved Congress's creation of a national bank in a statute that stated that the bank could not be taxed by the individual states. The states didn't like that. Maryland tried to tax the national bank, which had opened a branch in Baltimore. The head of the Baltimore branch of the national bank refused to pay its tax bill. Maryland sued, arguing that the Constitution didn't specifically authorize Congress to charter a national bank and that power could not be implied. The Supreme Court disagreed, concluding the powers given to the government would imply the ordinary means of execution. Without implied powers, the Constitution would have required dozens, if not hundreds, of amendments to address its many ambiguities and holes. If those holes went to the states for filing, we would have a patchwork of laws that vary from state to state, a difficult thing to manage in a national and global economy. There are some things that need uniform rules. So what's the point of the 10th Amendment if Congress can exercise all kinds of implied powers anyway? The Supreme Court has shifted back and forth since the 19th century over the question of whether to turn the 10th Amendment into a tool for striking down federal laws. Sometimes the court has upheld federal laws so long as Congress acts within the scope of its authority, but sometimes the Supreme Court has treated the 10th Amendment as a separate limit on Congress's power. I won't belabor the specifics of how the court has toggled back and forth over what to do with the 10th Amendment, other than to bookmark it as yet another example of the problem with pigeonholing judges as either activist or text-based. All judges construe ambiguity and have different views on how to do that. The Supreme Court approach to the 10th Amendment finally gave the text some teeth in 1992 when New York challenged a federal statute requiring states to safely dispose of radioactive waters generated within their borders. If the states succeeded in getting rid of the waste, said the law, they would get federal money. If they pawned their waste off to a neighboring state, that state could charge them money for it. The thorniest part of the statute had to do with a provision stating that if states failed to get rid of their waste by a certain date, they'd be forced to take title of the waste itself. What that meant was that people harmed by the waste could sue the state, versus the manufacturers or other private polluters who were responsible for the waste in the first place, for damages flowing from the radioactivity. The Supreme Court found the take title part unconstitutional because it was a congressional ultimatum. Either do as we say with the waste or it becomes your property, states along with the litigation fallout from it. The court accused Congress of forcing the states to adopt a federal law as if it were the state's own law, and thus to make them do the dirty work of Congress. Writing for the majority, Justice Sandra Day O'Connor explained that the federal government may not compel the states to enact or administer a federal regulatory program. The dirty work rationale played out again in 1997 when the court struck down the Brady-Handgun Violence Prevention Act, which mandated federal background checks on firearm purchasers and imposed a 5-day waiting period before people could buy them. The bill was named after former President Press Secretary James Brady, who was shot and sustained brain damage when a man named John Hinckley Jr. attempted to assassinate President Ronald Reagan in 1981. In that case, the court split 5-4 with Justice Scalia, writing the majority opinion, invalidating the law based on the 10th Amendment, among other reasons. By requiring state officials to conduct background checks, he reasoned, Congress was again conscripting state officials, here police officers, to do its bidding by getting them to enforce the statutes as if they were part of the federal executive branch. The problem with this view is that the language of the 10th Amendment certainly means that Congress can exercise the powers it already has under Article 1 and the power to pass legislation. Under the Commerce Clause, that power is broad and can implicate legislation that binds the states. Since that case, what has become of the 10th Amendment is odd. Congress can't make states do stuff to implement federal law, but it can prohibit states from doing something that's harmful. It can ban states from sharing personal information that people turn over to the Department of Motor Vehicles while getting a driver's license, for example. Enter the Affordable Care Act. It required some states to cover a certain percentage of low-income people within its Medicaid programs if they wanted to get any federal money for Medicaid whatsoever. Medicaid is health care for low-income people. Medicaid is for the elderly. Both were in place long before Obamacare came on the scene. Expand your programs, in other words, or you get nada, said the statute. In the opinion upholding the gist of the statute, Chief Justice Roberts declared this aspect a gun to the head of the states, and thus unconstitutional under the 10th Amendment. Given that there are so few Supreme Court cases actually striking down laws under the 10th Amendment, this one is important because it found the violation how Congress gave money to the states. It says that Congress can't condition federal funding on certain behavior by the states. Remember how the radioactive waste and gun control laws weren't about money? They were about making the states do something governmental, like clean up radioactive waste and conduct background checks. If the 10th Amendment turns into a squeeze on Congress's power to spend money, it could go a long way towards decreasing the federal legislature power relative to the power of the states, while at the same time increasing the power of the Supreme Court. An unelected branch of government to blow up federal legislation programs is that, in theory, are reflective of the will of the voting populace. Now that's a bit ironic, no? And that was Chapter 9 of How to Read the Constitution and Why by Kim Wehle.